A child reportedly banished to a backyard shed, forced to live without plumbing and essentially without dignity for months. Police in Pennsylvania say a young boy was locked away like a prisoner in his own yard, a punishment for what the adults in the home allegedly called inappropriate behavior. The shed had no running water and no bathroom. The child was reportedly only allowed inside the house once a week to shower and had to drink from a garden hose just to stay hydrated. But when he finally said enough, when he refused to go back into that shed, everything spiraled. Police say things turned violent, and what happened next led to 2 arrests. I'm Kennedi Walker, and this is Law and Crime. A Pennsylvania man who calls himself a man of God is now facing child abuse charges. Daryl Sensenig, a part-time bishop at a Mennonite-rooted church, and his wife Grace are accused of starving and isolating a child, forcing him to live in a backyard shed for months. According to police, the 41-year-old and his wife, 42-year-old Grace, were arrested after officers responded to a domestic disturbance. But it wasn't a fight between husband and wife, it was a violent confrontation between the bishop and the child. An affidavit obtained by Law and Crime says the couple punished the child for what they claimed were inappropriate behaviors by exiling him to a wooden shed 100 yards from the main home. That shed had no plumbing. The boy was allegedly forced to drink from a garden hose and defecate in holes he dug himself. Police say he wasn't even given toilet paper. Instead, he used leaves. He was allegedly only allowed to shower once a week inside the home and was rarely permitted to use the indoor bathroom. And as if that weren't enough, authorities say the child had to pay for his own food with money earned from a part-time job. But on July 30th, something changed. The boy refused to go back into the shed. That's when police say Daryl tackled the child to the ground and applied pressure to his neck. Officers who responded noted visible scratches and abrasions on the victim's arms and neck. Both Daryl and Grace were taken into custody. Daryl is now charged with felony child endangerment and misdemeanor assault. Grace is charged with felony child endangerment. They've since been released on $30,000 unsecured bail. As for the child, he is now in the care of extended family while officials continue their investigation. And here to break down this story with me is criminal defense attorney Enrique Latoyson. Enrique, thank you so much for coming on today.
Thanks for having me.
So let's just jump right in and let's be blunt here. I mean, how does a case like this even happen in 2025? Where's the legal breakdown?
Well, I mean, it's actually surprising that in this time in 2025 that people would still conduct themselves in a way like this, especially with all the internet and people being able to reach out to other people to be able to expose somebody that's being abused. You would think at this point people would know better to act like this as parents. You also can easily get on the TV or internet and see other examples of what not to do from other parents who've been charged with similar crimes. So it's pretty surprising that in this day and age that people would still conduct themselves in a way in treating a child like this.
Absolutely. And I mean, when a child is allegedly hidden away in a backyard shed, does the law consider that confinement or is it more complicated than that?
Well, I mean, it really comes down to it. In order for someone to be confined or say, being held hostage, so to speak, you would need information that, somehow, some way the child could never have broken out of this particular location. I understand the child did have a part-time job. Unfortunately, that part-time job is how this child was able to buy food in order to eat, which is absolutely shocking. But really what it comes down to when you're looking at endangering the welfare of a child, it comes to breaching that duty of support and endangering that child. And that's really what the law looks at in reference to the charges that these parents are actually charged with.
Yeah, when you just really start to dive into, the accusations by police, like how you mentioned him allegedly having to get a job and that's how he paid for his food. When you think about the shed, the garden hose, just things like that. I mean, okay, felony child endangerment, but does the law even begin to capture how severe this was?
So what's interesting actually about endangering the welfare of a child in Pennsylvania is it typically is a misdemeanor in the first degree. So if someone endangers the welfare of a child, breaches that duty of care or support of that child, it's a misdemeanor first degree. So when you see that these folks are actually charged with a felony third degree, that is your kind of that's your sign that the law is charging them with engaging in a pattern of endangering the welfare of a child. So when you engage in a pattern and you doing it constantly, or you're showing that you are considering and you're doing it over and over again, it gets upgraded to a felony third degree. So unfortunately or fortunately, the law doesn't really have say the egregious nature of what's taking place. All endangering the welfare of a child is not the same, because it's very fact specific, and it deals with exactly what's going on with that particular child and what those parents did. Now, what you will often see in cases like this, as more investigation is done and is dig deeper, you will also see more charges coming out, things that might have been alleged or things that might have been taking place at other times, other acts of physical abuse, sometimes sexual abuse, other different things that haven't come out initially. But normally what takes place is the initial endanger the welfare of a child, felony third degree is enough to get this child to safety and to get them away from the parents.
If you're prosecuting this, do you need to prove intent, or is gross negligence enough?
Well, you need to prove, first of all, that the parents were the ones that are in charge of the child. So, when you're charging someone endangering the welfare of a child, you have to make sure you're charging the right person. It can't just be, say somebody that stopped into the property or didn't really know or wasn't the one that was in charge. So that's the first thing they got to prove. Then they got to prove that what they did was they caused this danger to the child, and they breached the duty of support, and they breached that. And so it's not just gross negligence. You have to show that they did it, pretty much. I mean, the law is pretty broad in endangering the welfare of a child. I can read the actual, if you look at the actual statute, it just says a parent, guardian, or other person supervising the welfare of a child under the age of 18, which is important also. Can't just do this to anyone. For this particular charge, they have to be an actual child. And it's a person that employs or supervises such person. As I was saying, you have to be the person that's actually in charge. You can't just pick a cousin or a babysitter or somebody that might have just been passing through, and commits the offense if they knowingly endangers the welfare of the child by violating a duty of care, protection, or support. So to answer your question about exactly what the actual mental state is, it's knowingly. Knowingly means that you know this is happening in a nutshell. That's kind of what it means. And when you look at this, they knew their child was being, sent to a shed in the middle of this weather from March to June. They know this is taking place. They know they're allowing the child in once a week to take a shower. They know the child is getting food from money that the child is having to go and make money as a part-time job.
And just hearing all those things, I mean, it's just so hard to listen to. Police also say that there was visible injuries, but there's also long-term deprivation, right? Or deprivation here. So which one carries more weight in court, the physical or prolonged psychological harm? Because like how you mentioned, this kid allegedly spent months in this shed, March to, just going in through to the summer. So I'm sure just like mentally that really messes with someone's head.
And this is what, we were kind of discussing earlier with maybe the possible upgrading of the charges. Right now, there's a simple SART charge on there, which is knowingly causing bodily injury. But there's also a possibility things could be upgraded to aggravated assault. That would be if they was trying to cause extreme, permanent bodily injury, serious bodily injury, recklessly, and things of that nature. I do believe when these cases take place, they separate the child from the parent. So that's the first thing that takes place. And a lot of times when these children can get away from the abusing parent, they feel safer. They feel they're in a better position now to tell the full story. And so you don't know what the full story is at this point because the child's only been removed not that long ago. I mean, we basically we're right in the beginning of August, and this was the end of June when this was taking place. So when you're looking at that, the courts will take in the full story. This child will be able to do a victim impact statement. Pennsylvania has a standard sentencing guideline. They have an aggravated sentencing guideline. And so to answer your question, really all that information could go to pushing towards the higher part of a sentencing guideline for aggravated range. A felony third degree in Pennsylvania has a maximum penalty of 7 years in state prison. So, more information can come out to whatever the court would like to focus on in doing the sentencing, along with the participation from the victim, who may be willing to say more once this victim is no longer in that environment.
What if the victim, let's say they're too traumatized to testify? Then what happens?
So, in this particular case, they're going to need the victim for the majority of what they need to prove. First of all, they need to prove for it to be a felony versus a misdemeanor, as we discussed, need to show an ongoing pattern of that behavior. The victim's going to be the one that's going to be able to say that. Now, what's interesting in these types of cases, most of the time, these parents will talk to the police because they believe what they were doing was fine. They believe this was, they were treating their kid with, harsh, punishment, but, tough love, so to speak. They believe it's their parental rights as parents to do this. So a lot of times, defendants in these types of situations will be their worst. They'll be their worst victim. Them themselves will tell them themselves because they're proud of their upbringing, or they think their upbringing fulfills a religious or a cultural thing, and they believe that what they're doing is okay. In that particular situation, if they've said too much and they've incriminated themselves in under the guise of justification, then you will need less and less from that poor child. That instead of the poor child having to carry the case, the parents might have already incriminated themselves with enough information by standing by this type of parenting.
Yeah, you bring up a good point there, because a lot of times, these parents may think like, hey, I'm just disciplining them. And we didn't think it went too far, because, we've heard of parents locking their kids in basements, even bedrooms. And now in this instance, it's allegedly a shed. I mean, does the law actually differentiate based on where the abuse happens?
No, it doesn't. It doesn't based on where the abuse happened. But, endangered welfare of the child is one of those kind of situations where parents may say to themselves, well, listen, I'm not allowed to discipline my kid, and I'm not allowed to do all these things. And this type of charge is above the normal type of discipline. You have parenting styles that are like, let the kids run rampant and do whatever they want, and you have parenting styles where a parent might want to lock their kid in a bedroom, because they're afraid this child might sneak out, or this child might be doing something that's detrimental and dangerous to them. Locking a kid in a bedroom overnight while you go to sleep, may not be endangering the welfare of a child. Not feeding that same kid in the bedroom inside of a house, lock him in there, putting chains on him, locking screwing the window shut, leave him in there for days at a time. Well, now you've crossed over into something, that's, a felony. So, the law, understands that parents are different, and different parents have different styles. Some parents yell, some parents never yell, all these types of things. But, it wouldn't be based on where it was. Had they put the child in the shed for one night, and there was heat out there, or it wasn't a cold night and there were food, and they just, there was a light and there was different things, and they just left them there, just maybe as a timeout or something, and it was good intentions and it wasn't abuse, and the kid doesn't have marks on him and didn't have to feed himself. The law might not get involved for an isolated type of consequence that a parenting is punishing a child. But these types of cases, when you see it, you see it. I mean, we all see it. You're like, whoa, something here seems like it's a mess.
Now, how does age factor into this? Because we don't know the minor's exact age, but let's just say hypothetically, if he were 17 instead of, say, 11, does the law treat that differently, or no, because a minor is a minor?
Well, there is different gradings. I do believe if a child is 13 or under for aggravated assault, I know that there's a grading switch, and also the time should increase if the child is under 6 years of age. So if there's under 6, it also can increase the grading. So They just have to be a child. They could be 17 years and one day before their 18th birthday, and they're still endangering the welfare of a child. But if you're under 6, there's a special upgrading for that also.
Does this look like a trial case to you, or one that quietly gets pled out? And if you were, the suspect's attorney, how would you even go about defending this?
Well, in a particular case like this, I mean, I think a defense attorney would look to the origins of what was going on here, why were you doing this, and to get facts around, very fact specific about, what was the weather, how long was the child there, how often was the child there, what are these accusations about feeding the child, all these different things. And I think, like I said, most of the time these parents will confess their sins, so to speak, under the misconception that they are justifying what they're doing. And I think a case like this, ends up being a plea bargain, because you do have rare circumstances when you see these kind of charges, that there are parents who just didn't understand, or were making an innocent mistake, and those parents have to go to parenting classes and things of that nature. But that's normally in a situation where the district attorney's office or the police see that it was an innocent mistake or something they weren't aware of, or things of that nature. But in a case where you have public opinion that feels very strongly about the abuse of children, especially in a situation like this where it seems pretty cut and dry, most defense attorneys are going to suggest to their clients that maybe cutting their losses and trying to get a plea bargain and trying to get the best outcome would be the best situation.
Well, this is a story that we will be following closely. Enrique, thank you so much for coming on today.
Thanks for having me.
The couple is due back in court on August 13th. For Law and Crime, I'm Kennedi Walker.